In the second part of this presentation, I want to talk about specifically Alabama law. We've talked up until this point in rather generic terms, meaning federal laws that would govern health and health information, and now I want to be very specific as to certain things that are just specific to Alabama law, and those laws on the state level can change from state to state, so they would not be consistent. There's also something called health records in the Alabama law, which is actually what you'll hear me refer to as the Alabama Law Manual, and it's a manual published by our State Health Information Association, or the Alabama Association of Health Information Management. And this manual is used as a resource, and it is a very valuable resource for health information management professionals who practice in the state of Alabama. And it includes information in regard to the state and federal codes or written laws, statutes, the rules and regulations of administrative agencies that relate to health records and health information. And also, it gives position statements or recommendations from various organizations. They're not laws, but for example, AHIMA may have a position statement or recommendation on how long we should keep records. AHA, Alabama Hospital Association, or the American Hospital Association, the American Medical Association, different organizations can have position statements or recommendations in certain areas, and so those will also be provided. Now, the manual itself is divided into 21 chapters. It used to be, up until very, very recently with the latest edition, it's 12 chapters. So it's almost doubled in size, not totally, but it went from 200 and something pages to well over 550 pages. So it's grown considerably with this latest edition. But you'll notice that chapters 1 through 10 actually have to do with certain circumstances or situations. The first chapter talks about retention of health records, or how long we have to keep them. Consents, meaning consent for treatment. Confidentiality goes down. Subpoenas, chapter 8. How do we deal with subpoenas? They give examples of the different subpoenas that you may come in contact with. Also peer review and privilege and immunity for those conducting peer review. So certain circumstances are covered in chapters 1 through 10, where 11 through 21 actually cover particular sites or healthcare settings, such as rehab centers, hospice records, reproductive centers, birthing centers, and hospital medical records. Those are covered in chapter 18. And so the laws will be different. Alabama state law will be different in regard to these different settings. If we find out that you have to keep records for a certain number of years in a hospital, you can't assume that if you go to work in an ambulatory surgery center that that's the same, because it's not. The law is different. And so again, 11 through 21, particular sites where health care is rendered. Now, chapter 1 in the manual, which I'm going to show you in just a minute, has to deal with retention of records. I wanted to point out initially, in regard to retention of records in Alabama, that it is 5 years, and the reason that we know that is because the Alabama Department of Public Health, the licensure laws, they state that now in basically a roundabout way. I showed you in the first part of this presentation when we went to Alabama Department of Public Health's site to see the licensure laws for the state of Alabama for hospitals. It said that now we go by whatever the Code of Federal Regulations says. And if we in turn go to the Code of Federal Regulations, it says 5 years. And so that's why Alabama law is 5 years, because we're now in tune with the Code of Federal Regulations. Used to, we had to keep them 22 years, and it was very specific. In the Alabama Department of Public Health rules and regulation, it said hospital medical records must be maintained for a minimum of 22 years. So let me show you the actual manual. You'll notice I brought it up on the screen. It is a PDF file. It is now in digital format, and so instead of being a big paper binder manual with 550 some odd pages, now if you purchase this, and when I say purchase, you wouldn't want to go as a student or just on a personal basis and purchase this. Most every health information department will have this or should have this manual for reference. Now, as we go through, and we were talking about Chapter 1, I just want to go through the first 2 or 3 pages. Notice the table of contents. It's basically what I showed you on the slide. Shows you the table of contents, an overview or introduction on how to use the manual, and then the first page of every chapter will have an outline of what's contained in the chapter. So we were talking about Chapter 1, retention of health records. And it shows that in this chapter you'll find an overview of retention, and then the applicable laws and regulations both on the state and federal level, and then resources where you can go and actually look up the laws themselves. So when we talk about retention of health records, said that, okay, we have to keep them for 5 years because the Code of Federal Regulations says 5 years, and our Alabama Department of Public Health says, well, we're going to go by the Code of Federal Regulations. In each chapter, it always discusses or will discuss actual retention per setting. And so when we're in Chapter 1 and talking about retention of the health records, and we've already determined that we have to keep hospital records for 5 years, it doesn't mean that we're automatically just going to go and throw away all our records when 5 years are up. It doesn't say we have to throw them away then or destroy them at that time. It means that we have to keep them for a minimum of 5 years. And so in this chapter, it actually goes over an overview of what you might need to consider when coming up with a retention policy for a particular healthcare facility. And the first thing that it talks about under applicable laws and regulations is Alabama law in regard to the statute of limitations for bringing a malpractice lawsuit. So if we have to keep records for 5 years, we may want to keep them longer because the statute of limitations for bringing a lawsuit for malpractice may be longer, because we would want these records for defense of that type of action. And so if we look at the law, and the Alabama Law Manual does give it verbatim, it is actually the Code of Alabama 6-5-482 says, and I'm not going to read through this first section, is just, or subsection is actually one sentence, but it says, all actions against physicians, surgeons, dentists, medical institutions, and other healthcare providers for liability, error, mistake, or failure to cure, whether based on contract or tort, must be commenced within 2 years next after the act or omission or failure giving rise to the claim, and not afterwards. So that tells us a person will have 2 years in order to sue for medical malpractice. After that, statute of limitations is up and there won't be a lawsuit. But then there's some other circumstances in here. So we know just basically the statute of limitations for medical malpractice lawsuits, 2 years in the state of Alabama. So if we look on down into this subsection, we can see that provided that if the cause of action is not discovered and could not reasonably have been discovered within such period, within that 2-year period, then the action may be commenced within 6 months from the date of discovery, or the date of discovery of facts which would reasonably lead to such discovery, whichever is earlier, provided further that in no event may the action be commenced more than 4 years after such act. So, we're one step further. We say, okay, you have 2 years, or someone has 2 years to bring a medical malpractice lawsuit against a health facility or a provider. Unless within that 2-year period it wasn't discovered, and then if it was discovered, you have 6 months from the date of discovery that something is actually wrong, but it can never be more than 4 years. So now we're up to 4 years. And you can think, okay, well, we keep records for 5 years. If somebody has 4 years to bring a lawsuit, then we should be safe in that. But if you look at the next subsection 2, it talks about minors. And so subsection 1 above is subject to all existing provisions of the law regarding the computation of statutory periods of limitations for the commencement of actions, provided, notwithstanding any provisions of such sections, no action shall be commenced more than 4 years after the act, omission, or failure complained of, except that in the case of a minor under 4 years of age, such minor shall have until his 8th birthday to commence such action. So now we're up to 8 years. And so what that's saying is that a minor can have until his 8th birthday if something happens. So if a minor was a newborn, the very maximum amount of time that a medical malpractice suit could be brought would be 8 years. And so that's why many times in the state of Alabama, you'll see that hospitals will choose to keep records at least 8 years. They don't have to, but it's smart to do that because there could be a medical malpractice lawsuit at the maximum 8 years after the treatment was given, or an occurrence, whichever happens. And, like I said, with the newborn, it could be till that one's 8th birthday. And so that's why you see that there's a difference there. You'll also find many times that, especially now that things are electronic, or even if they were just put on microfilm, that's very expensive. And if we have them in a format where it's easy to keep them, a lot of times we just won't get rid of them. We'll just keep them forever and ever. But that's getting easier to do because things aren't as, paper's so voluminous, and if we have every record in paper, and back when we had to keep those for 22 years, there was paper everywhere, and we'd have to store it off-site, or we would have to spend the money to have it microfilmed. And so many times we'll keep records for a long, long time, even though we are not required to. So I wanted to show you, let's go back to the federal government's site. So this is the the Code of Federal Regulations, or the CFR. And when I showed you with the Alabama Department of Public Health that it referred to the CFR 842.24 as being the laws that the state would go by also, when we go to the medical record services, as we go down, we can find that under 482.24 section A1, medical records must be retained in their original or legally reproduced form for a period of at least 5 years. So that's where the federal laws are stating 5 years for hospital records. All right. Now, while we're on that topic, when we were talking about the medical malpractice law in the state of Alabama, let's look it up, and we would look that up under Allison website, because that's where the Code of Alabama is, and I jotted it down so I do know. I know y'all won't remember, but it was 6-5 5-482. So section 6. Whoops. So Title 6, Section 4. It's 4 or 5. -482. I wrote that one down. So let's go back one page. 6-5-482. If I click on that link, it's going to show me the exact law that we just viewed in the Alabama Law Manual about limitation of time for commencement of action, all actions against physicians, etc., etc., etc. Here it is, and here is the actual law, 6-5-482. And so if you are ever asked a question and say, according to the Code of Alabama, what's the statute of limitations for a medical malpractice lawsuit, and you go find the answer, and if I were to ask you to cite the law itself, I don't mean verbatim as listed here, you would say according to section 6-5-482 of the Code of Alabama. And so that is what that reference is. All right. Now, as I mentioned earlier, the retention will change depending on the actual type of facility. And so you can actually look those up, but they are given in the Alabama Law Manual under the chapter for a particular type of facility. Okay, Chapter 2 deals with consents. And when I'm talking about consents, I'm talking about consent to treatment. And so some of the applicable laws and regulations in Alabama under Title 22, Chapter 8 of the Code of Alabama, which would be under that Allison website. And again, that's just the electronic version. It's in a book, in a volume of the Code of Alabama, or the written laws. Under Title 22, Section 26-1-1 says, number 1, the age of majority in Alabama is 19 years old. Is 19 years. So that means you're an adult at age 19. That's the age in which you reach majority. Minors may give consent for health care at age 14, according to Title 22.8.4. So 22.8.4 of the Alabama Code says that a minor may give consent for health care at age 14. They're still minors, but in this instance, they are mature minors. And I know there's been some confusion on what's the difference between an emancipated minor and a mature minor. A mature minor is still a minor. It's just that under certain circumstances, they're given certain rights. So a minor would be mature at 14 for health care consent. Also, the Alabama law goes a step further and says any minor may give consent for treatment for pregnancy, VD, drug dependency, alcohol toxicity, or reportable disease according to 22-8-6 of the Code of Alabama. So, adult at 19, but at 14 may give consent for health care, but any minor, no matter the age, may give consent for treatment for pregnancy, VD, drug dependency, alcohol toxicity, or reportable disease. So let's look, for example, minor may give consent for health care at age 14. Let's go back to Allison. So we said that's Title 22. 22-8 4. And here's that law. Section 22-8-4. When minor may give consent, any minor who is 14 years of age or older, or has graduated from high school, or is married, or having been married is divorced, or is pregnant, may give effective consent to any legally authorized medical, dental, health, or mental health services for himself or herself, and the consent of no other person shall be necessary. Again, Code of Alabama 22-8-4. That's what gives that right. And many times when teaching this class, I hear parents go, not my child. They don't have permission. Yes, at 14, any minor can give consent for medical treatment. All right. Let's go back. And, for example, in Alabama, there's an implied consent to chemical test. So, under Title 32-5-192 of the Code of Alabama, that if you have a driver's license and operate a motor vehicle in the state of Alabama, you have given your consent to test for alcohol. And if you don't submit to that, then you're automatically have a 90-day suspension of your license at the minimum. And so that's also in the Alabama law. One thing I wanted to mention, it talks in this chapter, gives you information on applicable laws in regard to consent in special circumstances. And for example, there is a federal law, and they give it to you in the Alabama Law Manual. They cite the federal law, which is 441.257 through 258 of the Title 42 of the Code of Federal Regulations, that requires a specific consent form to be signed for Medicaid patients who are being sterilized. This consent must be signed 30 days prior to surgery, or 72 hours if an emergency for reimbursement to occur. So that's what's so wonderful about the manual, but that all of this information is basically gathered in one place so that you can refer to it, but there actually is a law on the books that says you have to use, if the Medicaid patient is being sterilized, this consent has to be used in order for reimbursement to occur. And they actually, in the manual, give you an example of that consent. Chapter 3 deals with confidentiality. And so it provides the state laws and regulations, the federal laws and regulations in regard to confidentiality of records kept by healthcare providers. And I know we've talked a lot about HIPAA and privacy, and also HIPAA and security. But before HIPAA came along, there's still laws in the books to protect the confidentiality of health information. And so it doesn't mean that we didn't have any laws. It's just the federal law put everybody under that same umbrella. So before that, there were different state laws, and they would vary, but we did have and still do have laws on the books regarding confidentiality of health information. Also in this chapter, it gives an overview of the laws in regard to when health information has to be released without patient consent. And we've touched on that. We talked about child abuse, communicable disease reporting, those things that have to be reported whether you have permission or not, because they're mandated by state law. Before we go any further, I wanted to show you in that Alabama Law Manual, when we get to Chapter 3, and don't let me make you dizzy scrolling down through here. that if we look, they also talk about confidentiality in regard to quality assurance or quality improvement records. Let me see. I'll find that one exactly. Well, I should have jotted down exactly what page that's on. Oh, here we go. Something that we've talked about this when we were in the regular textbook for this course, the confidentiality of accreditation and quality assurance credentialing materials, such as those incident reports and things, and how we should keep those so they won't be discoverable. But there is an Alabama law on the book that says that information is not discoverable, that attorneys cannot have access to the information that is gathered for accreditation, quality assurance, and other activities. And so, according to the Code of Alabama 22-21-8, that's where it protects that information and also gives the laws in regard to protecting the people that are doing the quality improvement activities. That if somebody is doing a peer review on another person's work, and I mean, it's basically mandated that these activities need to go on, and they're done for to increase quality of care for patients, then somebody can't come back and sue for those activities. But most importantly, that the particular documents, could be minutes of meetings for quality improvement, could be peer review that's gone on, that those are not discoverable in the state of Alabama. So protecting those types of records that we would keep in healthcare. Those aren't part of the patient's record, but part of the activities that we may well be involved in a healthcare setting. One other thing I wanted to show you here in this chapter, go down. I want to show you where it talks about availability of records to both parents. Now, in your Roach textbook, or the textbook for this course, we talked specifically and said that in general, when parents are divorced, the individual that can consent for release of information or that has access to the child's records is the custodial parent, and that as a general rule is true. But in the state of Alabama, we actually have a law on the books that says, unless otherwise prohibited by the court, so unless in those divorce proceedings or the custody hearings that it was said that this is not true, that all records and information pertaining to a child, including but not limited to medical, psychological, dental, scholastic, athletic, extracurricular, and law enforcement records, shall be made equally available to both parents in all types of custody arrangements. So that gives both parents access to the information unless, through the court has said otherwise. And so that's according to 30-3-154 of the Code of Alabama. All right. Now, one last thing I wanted to talk about is in regard to release of information in Alabama, that there is another regulation on the book through Medicaid that prohibits the release of health information on a Medicaid patient, including the billing records, from the records of Medicaid recipients without the prior permission from the Alabama Medicaid Agency, the third-party section. And this is something that you would not be made aware of anywhere else, because this is specific to Alabama and the Alabama Medicaid Agency. But what this says is that in the state of Alabama, that if you get a request for release of information on a Medicaid patient, you have to first contact the Alabama Medicaid Agency and get permission from it to release those records. And that's also in regard to if you get a subpoena, you have to contact Alabama Medicaid. Now, they have come out with a few exceptions now that HIPAA's in effect, is that that does not count if the patient just wants copies of his or her record, or if they're going to another healthcare provider for continuity of care. But the reason behind this is that, for example, if an attorney is wanting these records, it could be that the patient is suing somebody and going to get money, and if so, then Medicaid wants reimbursed for paying for that hospital care. And so that's why there's a block. And so you do have to get permission from Medicaid in order to release records, unless it's particular circumstances, before you actually release the health information on a Medicaid patient. Okay, Chapter 4, I'm not going to even talk about this. It goes over HIPAA, privacy and security, which we've done very thoroughly. And so it just talks about HIPAA, privacy rule, the security rule. It gives it to you in a nutshell. And also it gives an overview of HITECH included in this particular chapter in the Alabama Law Manual. But something very good in here is that there are sample consent forms, authorizations, privacy notices that can be used. So they're provided in the Alabama Law Manual. Chapter 5 gives information on the electronic health record specifically and e-discovery. Now, we've talked about discovery, and so there is an overview of that, and also ARA, and all of this relates to discovery of electronic health information. And we've talked about how there are questions about what actually is the medical record when we have all of this data kept on patients, and we don't just have pieces of paper that say discharge summary, H&P, progress notes. We know that those are parts of the record if they're in the paper record, but we have so much more data that we keep electronically on patients. And so this chapter gives a lot of good information on keeping that electronic health information, and also what to do in that discovery process when we are trying to determine what actually is the medical record. If you were to get a subpoena for records, what data are part of the health record? Chapter 6 talks about public health reporting. And we've talked about this in the regular textbook. I mentioned it a minute ago. But in Chapter 6 of the Law Manual, it actually gives you the actual state laws mandating reporting of births and deaths and fetal deaths, or vital statistics. It gives a list of those communicable or notifiable diseases that must be reported by law to the health department. Also, it gives the laws that state in the state of Alabama, spinal cord injuries have to be reported. Cancer has to be reported. Also tells in this particular law, as far as the cancer reporting, what cancers have to be reported, because not all of them have to. Also, child abuse and abuse of the elderly and domestic violence. So all of these laws are shown and given in regard to mandatory reporting. And also, there's a description and the laws that address immunity for reporting. So mandated by law, you have to report something. There's also laws on the books that say, okay, you reported this by law. You can't turn around and be sued for a violation of somebody's rights for reporting this information because you were mandated to by law. Oops. Now, Chapter 6 talks about psychiatric and substance abuse records. And we've talked about these. We talked about this in, I'll say we, if you had me for 153. Also, we've talked about it in this class. But the psychiatric and substance abuse records do have some special laws that go along with them. And there's both state and federal laws that address these particular types of records. So, we've talked about the federal mandate, which I'll show you in just a minute, about protection of alcohol and drug abuse records. But in the state of Alabama, there's a law on the book, and it says, no employee of any of the facilities under the management or control or supervision or affiliated with the Alabama Department of Mental Health and Mental Retardation shall be required to disclose any record, report, case history, memorandum, or other information which may have been acquired, made, or compiled in attending or treating any patient of said facilities in a professional character. And so it's going on to say that you have to have a court order, just as you would to get the alcohol and drug abuse records. A subpoena is not enough. But you'll notice one part of this I've underlined, and this is state law. It's federal law that protects those the substance abuse records. But state law in the state of Alabama protects psychiatric records to say that you cannot release those with just a subpoena. You have to have a court order. But I did underline this part when it says no employee of any of the facilities under the management, control, supervision, or affiliated with the Alabama Department of Mental Health and Mental Retardation shall be required to disclose these records. Not all psychiatric facilities are up under the control of the Alabama Department of Mental Health. Most are. Most mental health facilities are run by the state. So most everybody in most every situation in regard to psychiatric records would fall up under this law. But when I worked in the facility that had psychiatric and substance abuse patients, then we didn't fall up under that because we were a private entity. We were not associated with the Alabama Department of Mental Health. And so we did fill the subpoenas. We answered those subpoenas. We did not say, oh, you have to have a court order to have these records. Now, we would with the substance abuse records because federal law said we had to have a court order and a subpoena wouldn't be sufficient for the substance abuse. But for the psychiatric records, a subpoena was okay. But majority of the times that's not the case. You have to have that court order according to Alabama law for psych records. So this slide is just saying what I mentioned just a second ago about the federal law that addresses the confidentiality of the release of records from patients treated for alcohol and substance abuse covered under the Comprehensive Alcohol Abuse and Alcohol Prevention Treatment Rehabilitation Act of 1970 and the Drug Abuse Office and Treatment Act of 1972. And so there's the federal law for the substance abuse or addiction, and then there's state law in regard to the psychiatric records, and both of them state it's not enough to have a subpoena, you have to have a court order. And when we say that, and I want to remind you again, it doesn't mean you can't release those records if patients give you consent. I mean, that's fine. It's just we're talking about in court cases where they're subpoenaing records. That's when a subpoena is not sufficient. But you can always release it if you have permission of the patient. Now, Chapter 8 talks about subpoenas specifically, so subpoena of witnesses and records. And I wanted to go through very quickly and talk about this. We've talked about it before, about, records being subpoenaed. But this chapter in the Alabama Law Manual provides information in regard to who has the authority to issue a subpoena, what constitutes a valid subpoena, and how to answer it, maybe how to act when you go to court and you actually are subpoenaed, so how a witness should behave, him or herself. And so let's look at these just for a minute. If a copy of a medical record is used to answer a subpoena, it must be accompanied by a certificate of the custodian. And so when you get a subpoena for health records, it's directed toward the custodian of medical records. That's just the terminology that's used. And so in Alabama, the law states that under section 1221(7) that you can send a copy rather than the original when you have a subpoena of for health records. But if you do, then they have to be certified, and so the certification itself must be verbatim the certificate of the custodian of the health records provided in sections 1221(5) and 1221(6). So show the name of the parties in the case, proceedings, the name of the court, and it gives a description, but when it's filled out, it has to be filled out exactly. And so when you, and I say you, it's usually the director of health information that gets these subpoenas. That's actually the custodian of medical records. Then if we're allowed to send a copy rather than the original, we would take the copy and seal it in a sealed envelope with it all taped up and everything, and put this certification on the front so that it's away from the actual record, so that we can tell if the record's been opened or anything like that. But this certification, and they're actually, you can get envelopes with this printed on the front of them. And when I say envelopes, I'm talking about the big manila envelopes, and this is actually printed on there, and it's filled out when those copies of records are sent to court instead of the originals. And so the actual certificate or certification shows up in section 1221(7). It says you have to have this on the record if it's subpoenaed and you're sending a copy. Now let's look at the most common subpoenas that involve patient information. The ARCP, which stands for Alabama Rules of Civil Procedure, a Rule 34 subpoena. This is a type, you'll hear that said, well, it's a Rule 34. And this type of subpoena is a subpoena that you'll get, I say you, again, the Health Information Department will get that custodian of records during the discovery phase of a court case. So remember, in discovery, they're just gathering all the information that they can. And this one is unique in that it has a waiting period or time in which the other party in the case can object to that subpoena. Now, after the time period has expired, the records are mailed to the attorney who caused the subpoena to be issued, but the opposing counsel has a right to any records sent, but it's not the responsibility of the healthcare facility to do this. So let me explain this a little, and this is explained in the Alabama Law Manual about, okay, what do you do if you get a Rule 34 subpoena, and what is it? So again, it's in the discovery phase. You'll get a notice in the mail saying a subpoena is going to be issued within X number of days, and it can't be less than 15 days. And that notice is sent to the facility where the records are, and also the attorney for the opposing team in the lawsuit. So you get a notice, and it says we're going to send a subpoena within a certain amount of time. And so why they do this is so that the other side has a chance to try to have that subpoena blocked if they so choose. And so you get the notice in the mail. It says, be expecting a subpoena. And then you get the subpoena after that amount of time. And then it will have a time period in which you have to mail the records to the attorney who caused the subpoena to be issued. You don't take them to court with a Rule 34. You're mailing them to a particular attorney. Another thing that the Rule 34 subpoena, the Rules of Civil Procedure, say is that if you mail the records to one attorney who caused the subpoena to be issued or had the subpoena issued, then the other side has a right to exactly the same thing in that case. Now, where it gets a little bit touchy sometime in the real world is that the opposing side would call and say, I know that you mailed those records to this attorney, and according to Rule 34, I get the same copies. Well, that's true, but it's not our job to do that. The other side that got the records can make copies by law and give them to the opposing attorney. So hopefully I have not confused you too much in this, but just remember, Rule 34 is used during discovery. It has a waiting period on it. You don't answer it immediately. It will be very specific, but you get a warning that you're fixing to get one. Then you get it, and then you mail records to the attorney that had it issued, but you're not responsible for mailing a copy of everything to the other side. So that's what a Rule 34 is, as opposed to the most common that we'll get is a Rule 45 subpoena. And this commands the custodian of records to produce records, and this is when we talked about a subpoena ducis tecum. That's on these Rule 45s. A lot of times it will say you are to appear at 9 o'clock at this court, in this courtroom, and bring with you the medical records on such and such patient. But we can, by Alabama law, it is permissible to send a certified copy instead. And so we can do that and then mail them to the clerk of the court or deliver them to the clerk of the court. But sometimes the attorney that has this Rule 45 issued will be very specific and say, no, I want you to show up with the original. And so if you do, you have to appear in court with the original, but you'll take that certified copy with you to be able to swap them out. You don't ever want to leave the original record unless you are ordered by the court to do that. But most commonly, you get a Rule 45 subpoena. The sheriff comes in and delivers it. It's for particular records. It gives a date in which those have to be sent. You make a certified copy of the record and then send them to the clerk of the court, and they would be used in the court case rather than in that pretrial discovery. And so that's the difference. So the Rule 34 or Rule 45 is more of the subpoena ducis tecum, come and bring the records with you, versus that Rule 34. So hopefully, again, because that can get confusing, that I'm just narrowing it down to those two particular types of subpoenas. Now, in Chapter 8 in this Alabama Law Manual, it gives you examples of subpoenas and what they actually look like. And like I said, you can get them in the mail. Various individuals can serve subpoenas. It's usually, if it's a Rule 45, it's going to be the sheriff that comes by and brings the subpoena. Chapter 9 gives a background information on the grounds for lawsuits, which we've covered, and also some of the things that could happen or the consequences of releasing or improper release of information and the penalties for those actions. And it also gives guidelines on the proper way to conduct oneself as when called as a witness in court. And so on that, we've pretty much covered that totally when we went over the information in the textbook. Chapter 10 talks about peer review and privilege, and Alabama law deems certain information under those peer review statutes privileged. And we already covered this just a minute ago when we were talking about a previous chapter in the law manual, but in Chapter 10 it is covered, and it means that information used in peer review and those quality assurance activities is not subject to discovery and can't be used as evidence in a court of law unless the privilege is waived. And so we've already discussed that, but they go into it at length in Chapter 10. And I actually showed you that law, or in the actual Alabama Law Manual previously. And lastly, in regard to quality assurance, there's federal legislation that was implemented way back with the prospective payment system when all the DRGs came into being, and required that acute care hospitals participating in Medicare program enter into contracts with, at the time, what were called PROs, PROs, professional review organizations. Now they're called QIOs, quality improvement organizations. So it was a requirement, and also those QIOs or PROs at the time had the right to review medical records for medical necessity, for quality, for appropriateness of medical services that were rendered to Medicare patients. So many times they would ask for copies of these records, or they actually come to the facility and review the records. And so it's mandated that we have to give them access to those records. But also, those quality improvement organizations have a responsibility to maintain the confidentiality of that information that is released to them. Because remember, they contract, or you haven't gotten to this point yet, you will learn more about that. These are organizations that contract with the federal government and in order to do quality improvement activities and to view the quality of care given to Medicare patients. And so it not only says we have to give those records, but it also talks about the responsibility of those organizations that get those records as far as to maintain the confidentiality of that information. Now, finally, chapters 11 through 21, I already said the remainder of the chapters deal with specific sites for health care delivery. And so, since we've already determined, as I said, that hospital records have to be maintained, for example, 5 years. Remember, if you go to work somewhere else, you need to check and see, okay, I'm in a rehab facility. What has to be on our records? How long do we have to keep them? And says who? So those types of things are covered in the remainder of the chapters. And like I said, that would take forever and ever and ever to go through all of it. But I think that a good example is if someone comes to the hospital and has a baby, those records are mandated that they have to be kept for 5 years. But if somebody goes to a birthing center and has a baby, those records have to be kept a different amount of time. And they're very specific in regard to what has to be on those birthing center records and all of those different types of things, and that the mother and the baby's chart are kept this way and they're kept for certain amounts of time. So you always would need to check and make sure in regard to state laws in your specific site. And so that's an overview. I know I always say I want to give you a brief overview, and I don't ever do that, but I try to keep it as brief as possible. But that's an overview of the Alabama Law Manual and just some specific information on specific Alabama laws regarding health information.